This morning, on March 9, 2026, Chief Justice John Roberts of the U.S. Supreme Court delivered the most significant trade decision in the nation's history by reading it aloud. In just 6 words, he removed from the president the economic tool that had been used for more than a year to intimidate allies, disrupt worldwide markets, and force Canada into compliance. By a 6-3 vote, the justices determined that the International Emergency Economic Powers Act gives the president no power to levy tariffs. Period. No further appeals possible. No alternative path under that statute. Finished. The real drama unfolded in the hours that followed. Shortly after the decision was issued, Prime Minister Mark Carney's administration in Canada discreetly acknowledged that the U.S. Treasury now faces $175 billion in legal liability. That amount isn't an estimate or a symbolic figure pulled from a demonstration. It's the precise calculation from the Penn-Wharton budget model, one of America's leading nonpartisan economic research groups, representing the full sum of IEEPA tariff revenues now at risk of being refunded. This has moved beyond a simple trade conflict. It represents a major legal disaster for the White House and a massive structural gain for every country affected by those duties. What sets this apart from any trade episode in post-war U.S. history is that the Supreme Court, including 2 justices personally selected by Donald Trump, chose to tear down the legal framework he had constructed over 2 years. In this analysis, I'll guide you through precisely what the court decided, which tariffs were eliminated, and which ones remain intact, because that difference is hugely important. I'll detail the immediate reaction inside the White House after the ruling emerged and why insiders portrayed it as complete chaos. I'll describe how Trump tried to reinstate the invalidated tariffs on the very same workday by turning to another statute, and why experts in constitutional law are already labeling that approach legally shaky. I'll outline the specific implications for Canada, the $175 billion figure, Carney's formal response, and Dominic LeBlanc's recent comments in Washington that indicate Ottawa is now bargaining from a place of clear legal advantage. Finally, I'll present 3 possible ways this could reshape trade across North America ahead of the KUSMA review deadline on July 1st, 2026. Subscribe to become part of the community, drop a comment to continue the discussion, and share this video if you found it worthwhile. Let me take you directly through the ruling, since every phrase Chief Justice Roberts selected carried careful intent and real impact. The lawsuit contested Trump's reliance on the International Emergency Economic Powers Act, the statute the administration cited to defend tariffs against Canada, Mexico, China, and ultimately much of the world, framed as a reciprocal trade emergency. IEEPA allows the president to oversee international economic activity in a declared national emergency. The Trump team contended that regulate was expansive enough to cover import taxation, treating tariffs as merely one form of economic oversight. The Supreme Court rejected that view. In the majority opinion, Roberts stated that regulate and importation together cannot support such a broad interpretation. 6 justices concurred, 3 disagreed. The decision instantly nullified the IEEPA-based tariffs on Canada, Mexico, and China enacted under the so-called fentanyl emergency directives, along with the worldwide tariffs set under the reciprocal trade directive. Insiders familiar with the opinion's wording note that it was crafted with such exactness that any future effort to revive tariffs via IEEPA would be struck down at the district court stage long before appeals could begin. The pathway isn't merely blocked, Roberts sealed it permanently. First, the fentanyl tariffs are gone. Trump placed 25% duties on Canada and Mexico, pointing to border protection and fentanyl smuggling as the emergency basis. Canada had long argued the label was unjustified, since Canadian fentanyl seizures make up far less than 1% of total U.S. seizures, with most entering via the southern border. The court effectively endorsed that by holding that IEEPA cannot authorize tariffs no matter how the emergency is described. The claimed crisis was irrelevant. The statute forbids it. Second, the reciprocal tariffs are gone. The administration had rolled out tiered reciprocal duties on partners worldwide, hitting Canada with extra economic strain. All of it vanished. Courts will now handle separate lawsuits, and companies will start seeking refunds for roughly $165 billion in paid duties, the Penn-Wharton estimate of total IEEPA tariff income gathered so far. Third, Section 232 tariffs remain standing. This key detail gets downplayed by most coverage. These are the measures inflicting the greatest harm on Canada: 25% on steel, 10% on aluminum, 25% on automobiles, plus those aimed at softwood lumber. They stem not from IEEPA, but from Section 232 of the 1962 Trade Expansion Act, which permits import restrictions when national security is at stake. The Supreme Court left Section 232 untouched. Those duties persist. Canadian steel and aluminum shippers, exporting about $35 billion worth to the U.S. in 2024, continue paying them. Canadian car producers keep suffering losses. Fourth, Trump's immediate workaround. Hours after the decision, the White House declared a new 10% global import surcharge under Section 122 of the 1974 Trade Act, a separate legal basis, taking effect in 5 days and lasting 150 days. The Section 122 measure included one major exception: goods qualifying under KUSMA, the Canada-United States-Mexico Agreement, are excluded. That carve-out isn't kindness, it's calculated. It discourages Canada from exiting KUSMA ahead of the July review. Fifth, 24 states filed suit right away. On the day the Section 122 surcharge was revealed, 24 attorneys general launched a federal case contending that Section 122 demands an actual balance of payments emergency as a prerequisite, and none exists. Legal analysts consider this challenge to have strong prospects. Success would dismantle the substitute tariff system just as the original one fell. Subscribe now, because what follows covers events inside Ottawa, the White House, and the urgent trade discussions in Washington on March 6th. Plus, why the figures Canada brings to those talks are unprecedented in U.S. dealings with any partner. Diplomatic contacts report that the Canadian government had simulated precisely this outcome. Carney's trade advisors monitored the Supreme Court litigation for months, and their internal reviews concluded a favorable outcome was more probable than financial markets assumed. When the ruling arrived at 10:02 a.m. on February 20th, Ottawa's reaction wasn't jubilation. It was calm execution of a prepared legal and diplomatic plan. Trade Minister Dominic LeBlanc released a statement within 90 minutes, noting that the decision strengthens Canada's view that the U.S. IEEPA tariffs lack justification. The language was measured and strategic, since LeBlanc's group understands every dollar taken from Canadian shippers under IEEPA is now potentially reclaimable, and the total is enormous. Conservative leader Pierre Poilievre described it as progress, but emphasized that duties on steel, aluminum, lumber, and vehicles persist and keep hurting Canadian employees. That assessment was accurate. The ruling delivers a legal win, not yet an economic one. Pain continues via Section 232, yet the broader tariff framework has crumbled, and Canada negotiates with that reality in its favor. Earlier this week, LeBlanc met U.S. Trade Representative Jamieson Greer in Washington, the first face-to-face senior trade discussion in months between the neighbors. Talks had stalled since October, apparently due to White House anger over a Canadian TV ad citing Ronald Reagan's tariff criticisms. LeBlanc presented Canada's new lead negotiator Janice Charette and new ambassador Mark Wiseman. Both sides called the exchange productive and detailed, with plans to reconvene soon. Receipt 1, the numbers. Through January 2026, the U.S. Treasury collected $165 billion in IEEPA tariffs. Penn-Wharton estimates total refund liability at $175 billion once interest and penalties enter pending claims. Canada doesn't collect that money directly. U.S. importers, firms, manufacturers, and retailers who paid can seek it via the Court of International Trade. Each refunded dollar weakens the economic rationale for the tariffs and strengthens arguments that the IEEPA strategy was a costly, unlawful error. For perspective, typical U.S. households faced roughly $700 in added costs from the 2026 tariff wave. Voters will remember. Receipt 2, the Section 232 protection. Remaining duties, 25% on steel, 10% on aluminum, 25% on autos, affect around $35 billion in yearly Canadian exports to the U.S., equaling 1% of Canada's GDP. That's substantial. General Motors has warned investors that its 2026 projections include $3 billion in tariff-related risks. Canadian families face an estimated $1,700 to $2,000 in extra yearly expenses from all tariffs combined. The Section 232 hold means suffering persists despite the IEEPA collapse. Canada recognizes this, which is why LeBlanc's March 6 session was a tough new round, not a celebration. Receipt 3, market response. After the ruling hit this morning, the Canadian dollar rose 0.8% versus the US dollar in the first half hour of trading. Toronto's materials index, covering steel and aluminum firms, surged. In the US, the S&P 500 materials group fell 1.4% as investors reassessed the tariff structure's legal stability. Bond markets in both nations reflected the change. Institutional investors uniformly concluded that the legal basis of US trade policy had fractured more severely than the White House acknowledges. Receipt 4, the strategic mindset shift. For 14 months, the Trump administration assumed IEEPA granted near unlimited power to apply economic coercion on any country, anytime, under any proclaimed emergency, at any rate. That belief enabled unchecked threats and escalation, since Congress, courts, and global institutions seemed too sluggish to intervene. One Supreme Court decision demolished that premise. As a high court ruling, not a lower court order, there is no appeal, no delay tactic, no stay possible. The power has vanished. The aura of boundless presidential trade authority, the intimidation factor central to every White House negotiation, has been shattered for good. Here's the Washington scene when the decision landed. It was released this morning with simultaneous notice to the U.S. Trade Representative and White House. Administration sources say initial legal staff analysis viewed it as less severe than expected. Only IEEPA tariffs invalidated, Section 232 preserved, creating brief relief. That eased within an hour once they grasped the $165 billion refund risk was real. Firms had already lodged precautionary refund claims anticipating this outcome. Soon afterward, the National Economic Council held an urgent meeting. The key issue wasn't appealability, none exists, but what tools remained to exert tariff leverage until a substitute was ready. Answers pointed to surviving Section 232 and Section 301, plus Section 122 as a broad interim option despite its vulnerabilities. By late morning, the choice to invoke Section 122 was locked in. Trump then received his briefing. Sources describe his anger as targeted and telling, not mainly at the legal outcome, but at the fact that 2 of the 6 opposing justices were his own picks. He allegedly demanded names of those who recommended them and whether anyone foresaw this. He called the decision a disgrace and betrayal, repeating betrayal after staff explained the court couldn't be swayed to revisit and that the majority spanned ideologies. Roberts, Sotomayor, Kagan, Gorsuch, Barrett, Jackson. Trump reportedly stayed quiet for almost a full minute. That pause conveyed to everyone present how deeply he grasped the implications. Hours later came the official White House response. Trump labeled the ruling profoundly disappointing, expressing shame toward justices who opposed American workers and the president's duty to shield the economy from unfair practices. It stated the administration would swiftly explore other legal avenues to sustain necessary trade protections. In plain terms, the Section 122 plan was already underway before the words were released. By early afternoon, Congress reacted from opposite angles. Senator Chuck Schumer termed it a complete rejection of the president's trade approach and urged legislation barring emergency powers for tariffs forever. Senator Marco Rubio backed Trump, claiming judicial intrusion into executive foreign affairs. Yet the outlier was Republican Senator Lisa Murkowski of Alaska, whose state relies heavily on Canadian roots for agriculture and energy exports. She stated plainly on record that the ruling upholds the core idea that emergency powers have boundaries, and boundaries aren't frailty, they're the law itself. When a GOP senator reminds the White House that law binds the president too, the defeat transcends party lines. It becomes systemic. By evening, the 10% global Section 122 surcharge was formally unveiled. Markets finished uneven. New legal fights are already forming. Here are 3 potential paths forward. Scenario 1, enforced rollback. The 24-state Section 122 suit prevails in federal court within 60 days, halting the new tariffs during litigation. Stripped of both IEEPA and Section 122, the White House retains only narrower, slower Section 232 and 3-on-1 options. Canada and the U.S. approach KUSMA review talks in coming weeks, with Washington holding far less bargaining power. Carney leverages the legal gap to insist on lifting remaining steel and aluminum duties as a KUSMA renewal condition. Facing elections without tariff income and facing refund demands in the hundreds of billions, the White House accepts partial concessions. KUSMA renews with changes favoring Canada. Scenario 2, prolonged standoff. Section 122 survives early legal tests on procedural grounds. The July 1st KUSMA review deadline arrives amid ongoing talks. The U.S. hints at non-automatic renewal, favoring separate bilateral deals with Canada and Mexico. Canada rejects bilateral talks absent Mexico. Mexico, strengthened by other economic ties, declines separation from Canada. The trilateral structure endures, not from goodwill, but because fracturing it would end the Section 122 KUSMA exemption, hurting U.S. firms worse. Bargaining stretches into autumn. Markets brace for 18 months of doubt. Workers across all 3 nations pay the price. Scenario 3, lasting break. Section 232, duties on steel, aluminum, autos, and lumber endure through 2026. Despite all challenges to IEEPA and Section 122, Canada's GDP takes another 1.52% hit. Domestic pressure speeds trade diversification beyond the U.S. exports to the EU rise. Energy agreements with Asia advance. KUSMA renews formally, but becomes largely empty as Canada and Mexico reroute growing shares of commerce away from the U.S. The Supreme Court victory stands as a historic marker the moment the law asserted limits, but the economic toll is irreversible, and ties are fundamentally changed. I'm closely following whether the 24-state Section 122 case secures an emergency injunction in the next 30 days, whether any large North American car maker openly shifts supply chains due to persisting Section 232 auto duties, and whether the Carney government begins actively pursuing refund claims for IEEPA tariffs on Canadian exporters' behalf. If Ottawa shifts from legal signaling to concrete financial demands, this enters uncharted modern territory. The Supreme Court eliminated Trump's tariffs. The U.S. Treasury now confronts $175 billion in legal exposure. And it was Trump's personally chosen justices, the ones he insisted would safeguard his priorities, who delivered the votes that collapsed the whole system. That's not mere coincidence. That's the law functioning precisely as intended. With 114 days left until the KUSMA review deadline, the United States negotiates deprived of its strongest leverage,